Today's topic, we're going to speak about statute of limitations. In other words, time limits to commencing a lawsuit. This is a really important one to know if you've been injured or if a family member has been injured in an accident, whether it's a car accident or premises liability or medical malpractice, whatever it might be. Time is never on your side when you're injured. These time limits are often referred to as statutes of limitations. And what that is that's a law that says you only have a certain period of time within which to commence a lawsuit. And if you don't commence a lawsuit within that prescribed period of time, with very few exceptions, you will be barred from ever bringing your claim, despite the fact that you might realize later that you have a serious claim and a claim with merit. Sometimes those limitation dates, there could be special limitation dates, special notice requirements, depending on who the prospective defendant is. So for instance, in claims against government entities, municipalities, things like that, there are extra notice provisions and shorter limitation dates. So the point is, it's really important after an accident to get advice early. Speak to a lawyer, find out what your rights are, what your obligations are to preserve your claim. Many people fear that if they speak to a lawyer, it means they're committing to bringing a lawsuit. That's not necessarily true. Most lawyers, our office for instance, we give free consultations. They are completely confidential. There is no obligation on your part. And so you can have your questions answered, get some advice, some information, and hopefully make an informed decision. And sometimes that decision might be to sign up with the lawyer and commence a claim. And other times it will give you peace of mind that maybe you don't need to act quickly and you have time to think about it and see how the injuries impact you as you go through your rehabilitation or recovery. People also wonder, if I do want to bring a claim, how long should I wait? For instance, if the statute of limitations is as much as 2 years, is it okay to wait? And maybe I'll just call a lawyer closer to the anniversary date. The problem with that is many lawyers will not take cases when you get too close to the limitation date. There's important reasons for that, but I can just speak about my own practice. We're typically I'm reluctant to take a case the closer it gets to the limitation date. There is investigation that needs to occur before a lawsuit can be filed. There's no guarantee that we'll be able to collect, analyze, and really figure out all of the issues, all of the facts with only a limited amount of time. People think months is plenty of time. They think 6 months or a year, that's plenty of time. In fact, sometimes it's not. It takes time to identify who has the records, request the records, as information is gathered. Sometimes it leads to additional information that's necessary for the lawyer to review so that they can adequately identify who all of the prospective defendants are and also understand if the case has merit. Another important point is that evidence is lost, destroyed, memories fade with time. It could be difficult for the lawyer to obtain the necessary evidence to ultimately prove that somebody else is at fault for this accident. And that could occur, like for instance, in a premises liability case, a slip and fall case. If there were witnesses, maybe they don't have as good of a memory now. Measurements to be taken, data to be collected, that might be lost. Waiting too long could actually undermine your ability to be successful in your claim later. So again, speak to a lawyer early, get advice so that you can make an informed decision. Maybe you're going to make a full recovery. Maybe the case is a really modest case, but many lawyers will take those on early and basically just monitor that case. But at least they're preserving and collecting the information if necessary. And you can always continue to communicate with that lawyer about whether in fact you want to file a lawsuit or not. you have some protection there because you have a lawyer that's aware of the deadlines and also aware of the information they need to collect in the event that a lawsuit becomes necessary in the future. If it's a contingency fee agreement, and I'm not going to get into details on that now, but we have another video explaining contingency fee agreements. It will not cost you anything in most situations to have a lawyer retained to protect your rights in the event that a claim becomes necessary. So usually the time limit or the statute of limitations starts to run from the date the accident occurred. So the injury event, the clock starts to run immediately from that date. And it doesn't matter if your symptoms start days later. There are situations where the statute of limitations is what we would call tolled or suspended for a period of time. Oftentimes that would occur where there's incapacity of some sort. So somebody was incapable of making a decision to commence a lawsuit. But again, those are really unique circumstances. Speak to your lawyer about whether or not that applies in your particular circumstance. Waiting to speak to a lawyer usually is more harmful. The insurance company would typically get notice of the potential for a claim, whether you give them that notice or not. If there was an injury event on a premises, if it's a department store, for instance, a sporting venue, whatever it might be, they typically have a process of risk management, which includes completing forms, taking photographs, preserving evidence, and reporting all of this information to their insurance company. So the insurance company already knows that there's the potential for a claim. It's really quite possible that the insurance company is already putting in place its defenses. So while you're waiting to decide whether or not to speak to a lawyer, the insurance company is already building a case, building a defense against you. If you wait too long, you and your lawyer will be at a great disadvantage because the insurance company has already had the benefit of collecting information and speaking to people, obtaining experts to defeat your claim. Right out of the gate, you're at a disadvantage. In a car accident, it's the same thing. The parties to the car accident will typically report the accident to their insurance company because presumably there's property damage, and the insurance company will be aware that there is a potential claim out there. Somebody may have been hurt. They will mobilize and use their resources to try to build a defense before you even get started. Don't give the insurance company opportunity to have even greater advantage than they already have. Speak to a lawyer early so that you can be on equal footing and ultimately obtain a fair resolution. We hope you found this topic informative. If you have any other questions, feel free to reach out to us. You can request a free consultation. Our contact details are listed in the show notes below.